Smith in the firm's Philadelphia, Pennsylvania office. He handles complex personal injury and product liability litigation and has overseen the development of legal defenses, master briefs, and dispositive motions in numerous mass torts. He's a member of the Products Liability Advisory Committee and has sat on its case selection committee since 1997. And most importantly to us, because he's such a font of wisdom and information, he's the founder and co-host of the award-winning Drug and Medical Device Law blog, which I personally read on a very regular basis, and many other people here at WLF do as well. Speaking second will be Phil Goldberg, who's the managing partner of the Washington, D.C. office of Shook, Hardy & Bacon, where he practices in the public policy group. He also co-chairs the firm's national amicus practice. Mr. Goldberg has testified before state legislatures, authored legal scholarship, and spoken at judicial and attorney conferences on some of the highest profile liability issues in the last decade. In 2015, he was named the director of the Progressive Policy Institute's Center for Civil Justice and is also a member of the American Law Institute. Jim, I'll let you get us started.
Okay. Thank WLF for having me. I've always enjoyed working with WLF, going all the way back into the 1990s with the classic WLF litigation involving off-label use. Today, however, the subject is personal jurisdiction and venue, and this is a law school type subject, and what we've all learned in law school about personal jurisdiction isn't true anymore. General personal jurisdiction is no longer just continual and extensive business contacts, which for a large business means just about anywhere. Now it is at home. Specific jurisdiction used to be minimum contacts with the place where the plaintiff was injured. Now we are looking at the defendant's relationship with the forum and, more importantly, its purposeful availment of the forum. And there are several other jurisdictional issues which have also generally been changing for the better. Now, what has the Supreme Court done? I'm assuming a sophisticated audience, so I'm not going to go into this in great detail. These are the four most important Supreme Court jurisdictional cases of the last few years. Daimler versus Bauman, which I call Bauman. It was general jurisdiction, then is effectively limited to the principal place of business or state of incorporation, which is where the corporation is at home, with the exception of an exceptional case, which is so exceptional they haven't found one yet. Walden versus Fiore was a specific jurisdiction case, and it stands for the proposition that the defendant's suit-related conduct must have a substantial connection to the forum state. You don't have specific jurisdiction where the defendant itself had no contact with the forum. The BNSF case from the last term, no specific jurisdiction based on doing business unrelated to the plaintiff, no matter how much business is. And then the BMS case versus Superior Court, a mass tort case, which is important for our line of work, that the contacts of other parties, be they other plaintiffs or other defendants, cannot create specific jurisdiction where there is neither the defendant nor the plaintiff are in the jurisdiction. And so this is probably the most important of the cases, because this was a 8-to-1 decision written by Justice Alito, and that becomes important as we will see. Now, the problem for the plaintiff's bar now is that their mass tort litigation business model depends on aggregating plaintiffs from around the country into certain pro-plaintiff jurisdictions, regardless of where the defendants or the plaintiffs are from. Bauman eliminated general jurisdiction as a basis for this business model. So then the plaintiffs tried to shift to specific jurisdiction, alleging that the presence of other in-state plaintiffs or other in-state defendants was sufficient to create an in-state relationship with the jurisdiction. That is now dead. BMS killed that decisively. The relevant relationship is the defendant to the forum and not anyone else. So the question then is, where do the plaintiffs go from here? Because they have invested tremendously in this business model. And there are two major things, which are the general consent jurisdiction in the various states based on the corporate registration statutes, and more attenuated substantial relationship specific jurisdiction arguments. General jurisdiction by consent is based on a case that is a century old this year. It is pre all of the modern forms of jurisdiction and is generally thought by most states to be out of date and obsolete. The only Supreme Court precedent therefore is not where the states have gone. This is not nearly as broad a solution or an easy solution for the plaintiffs, as many states have already rejected this on state law grounds because the statutes themselves do not have supportive language that compel the kind of result of having a jurisdiction for general jurisdiction everywhere. And this is a theory that, if adopted by everyone, would be just as grasping as anything that was rejected in Bauman. Now, there is one exception here, and this is why I think my home state of Pennsylvania is going to be the cockpit of this argument. And that is because Pennsylvania is the only state with a corporate registration statute that specifies general jurisdiction. But that shouldn't matter. If every state did that, and New York has been considering it, that would be the same kind of jurisdiction for everybody, anywhere, that was rejected in Bauman. And Bauman is, of course, a constitutional due process argument, so a state statute cannot overcome the due process considerations that the Supreme Court has been applying in these cases. Now, after BMS, what kind of substantial relationship do we have for specific jurisdiction? BMS did not categorically rule out that a non-resident plaintiff ever having a substantial relationship with a non-resident defendant within the jurisdiction, but it will have to be very firmly case-linked. Does the so-called arise out of relationship go beyond the injury in the forum? Possibly. BMS distinguished the situation where, in a mass tort case involving a prescription drug, where there was an in-state prescription or an in-state filling of a prescription in a pharmacy, even if the plaintiff were a non-resident. We also had the statement there that unrelated research is irrelevant. But what about related research? And this is where we could see possibly jurisdiction expanded to maybe 1 or 2 additional states, such as a state of manufacturing, the case involved a manufacturing defect, or the same of design for a design defect, or possibly a state of prescription if the plaintiff did not live in the state where the drug was prescribed by the learned intermediary physician. But what I can't see, and I don't think we'll see ultimately, is reducing this arise out of jurisdiction and relationship until it becomes as grasping and exorbitant as what the Supreme Court has rejected under other theories. This has come up in the prescription drug area in cases involving clinical trials where a case in Illinois and a district court case in California have said that any clinical trial is enough to support specific jurisdiction, even if it had nothing to do with the particular plaintiff or the particular injury. That is, however, in that case involved 44 jurisdictions, and this is the same kind of grasping relationship that I don't think the Supreme Court wants to engender. In Illinois, in cases that happened last week and that I blogged about on Monday, Judge Herndon has rejected this argument in 7 different cases involving the Xarelto. And furthermore, the Illinois Supreme Court, in a case involving general jurisdiction, rejected the same theory under another name in a case where the claim was made that any warehouse that the defendant operated would serve as a basis for jurisdiction. So this is one place where the plaintiffs will go. I suspect that Illinois is likely to be the cockpit of this one. Unfortunately, the Illinois appellate court case, I was hoping for a GVR on that in light of BMS, but that didn't happen, so the plaintiffs lived to fight at least another day on it. What did I do? It went blank. Anyway, the next thing I had was a slide about how to get all the way over there. Okay. Jump. Oh, there's a, that's interesting. It's a slide that's missing. I had a slide in here about increased attempts to pierce the corporate veil. I was going to skip pretty much over that because the substantive legal disputes aren't that different. It's just that I've been watching these jurisdictional cases for several years now, and I can see the increase in these, but as long as the defendants dot their I's and cross their T's, that shouldn't be much of a problem for a large company. But it does go and give the plaintiffs a basis for trying to get jurisdictional discovery. So what can we do about that? because in this situation, jurisdictional discovery is basically a weapon for delay and to go and try to increase the nuisance value of cases. Well, far more courts deciding things post-Bauman have rejected jurisdictional discovery than have allowed it, and I collect those cases on my Bauman cheat sheet that I do on the blog, so you can see them, and I make a notation every time we see those. Usually the plaintiffs are trying to make up something that's not been pleaded, and that's the first basis. It's outside the complaint, and therefore the plaintiffs are just engaging in a speculative goose chase and don't even have pleadings to back this up. Furthermore, under the Twickball principles of the Supreme Court's pleading, discovery follows pleading, it doesn't lead it. And furthermore, the scope of this discovery should be limited. In BMS, the court said that contracting with an in-state distributor is not sufficient to obtain specific jurisdiction. The defendant has to have contacts with the jurisdiction, not just contacts with others that have contacts with the jurisdiction. So the scope of discovery can be limited in that fashion. And finally, if this becomes a repeated situation where the plaintiffs are seeking broad, unnecessary discovery in an attempt to go and slow down jurisdictional motions, it might be worth the one-time expense of drafting a Rule 11 motion or brief that you could file in multiple cases and seek sanctions once the predictable discovery comes up there. Now, oh, that's what it is. It's out of order. Okay. Now for the good, even better part. How do we on the defense side take initiative? This is enough of playing defense. Let's play a little offense here. And I've seen at least 7 different ways where I think the defense can take the initiative after BMS. And they're listed here, and I'm going to go through them each time. You've got fraudulent misjoinder, which I've averted to. You've got non-resident plaintiffs in multiple defendant cases, stream of commerce jurisdiction, MDL practice, ancillary discovery, nationwide multi-state class actions, and personal jurisdiction in federal causes of action. Fraudulent misjoinder is the one that has actually preceded BMS. This is a situation where you've got multi-plaintiff cases where plaintiffs from all over the country with at least one non-diverse plaintiff for the defendants are piled together in cases up to and not quite reaching the CAFA limit of 100 cases, where you would run into other problems. So it's just enough to defeat diversity jurisdiction and not enough to reach CAFA, but no more. There is a Supreme Court principle in this Ruergas case that you will see on the slide that says that you can decide personal jurisdiction before subject matter jurisdiction if the first is easy and the second is hard. And after BMS, personal jurisdiction is a lot easier than wading into the morass of fraudulent misjoinder and CAFA. And therefore, what happens then, once you get to personal jurisdiction, it becomes much easier. All the non-resident plaintiffs get dismissed because they're suing non-resident defendants. And that is gone under both BMS and under Bauman. That gets rid of the non-diverse plaintiffs. The remaining plaintiff or two which are left from the jurisdiction remain diverse and stay in the federal court. Now, there's a special issue for multi-defendant litigation. This is basically asbestos cases. Clustering of non-resident plaintiffs in their favorite jurisdiction happens widely in asbestos, but this happens differently because in asbestos, unlike the other kinds of mass torts, the plaintiffs sue dozens, scores, sometimes even hundreds of defendants. And if they're not in the jurisdiction, then they're going to lose jurisdiction over the defendants that aren't at home and that the non-resident plaintiffs don't have any specific contacts with. That business model is failing as well, so the non-resident asbestos plaintiff is going to be out and lose a great majority of its named defendants anyway because of personal jurisdiction, so they either have to sue where they live or they limit the number of defendants. And since the asbestos plaintiffs have no idea normally what they've been exposed to, that will cause them a severe amount of reduction in the number of people that they can sue and where they can sue. The next thing, and I haven't heard much said about this, is stream of commerce jurisdiction. Since the 1980s, defendants have been dealing with this form of specific jurisdiction, which is based on minimum contacts where there are actually no contacts, only the actions of unknown, unidentified third persons in the marketplace moving products that are initially sold elsewhere into the jurisdiction. This is a situation where there is no purposeful availment of conduct related to the state because it's like the situation in the Nicastro and Asahi cases where these are usually, if not usually overseas companies, and they sell through a single nationwide distributor, if that, and then the products are durable products and they move around the country and eventually someone gets injured. This has never commanded a majority in either of the two Supreme Court cases that have decided it. But with BMS reiterating that personal jurisdiction depends on each party's separate jurisdictional contacts, then it looks to me like stream of commerce jurisdiction is headed for a fall. The primary concern of personal jurisdiction in the specific jurisdiction cases, and this is a type of specific jurisdiction under BMS, is the burden on the defendant. General connections are not enough. Relationships with third parties, such as these unknown and unknowable intermediate distributors, is not enough. Foreseeable harm in the state is not enough, and that's significant because foreseeability is all the stream of commerce jurisdiction has ever been based on. We missed picking up a win in Nicastro because we did not get Justice Alito's vote on the basis of what he has said. In the BMS case, I think it is the time is right to try to push a case to the Supreme Court, because I think stream of commerce jurisdiction after BMS is unlikely to survive. And a case in point I've been thinking about ever since the AEP versus Connecticut case eliminated the idea of a federal common law in air pollution cases are these climate change suits. Because the defendants are usually regional power companies sued in places where they do not do business, and so therefore they're not at home in these states. And since they are generally limited geographically, they're geographic monopolies in individual states. You have their only basis for jurisdiction is a sort of stream of commerce based on atmospheric convection. It's sort of stream of pollution type of jurisdiction, which is incredibly grasping and exorbitant if you think about it, that the weather would allow any power company to be sued anywhere over its activities anywhere. And since there is no federal common law, there's no federal basis for these suits, and I think that this is a situation where it's going to be impossible to go and get personal jurisdiction over these out-of-state power companies, and to the extent that climate change litigation continues. It had been dying off, but now that the administration is looking less favorably on climate change as an administrative matter, I think we might see an attempted pickup here, and this is one way to try to defeat that. Another place where I think we should look to play on BMS in particular is MDL practices. MDLs are being increasingly abused to force defendants to settle through exorbitant costs and exorbitant show trials. And I tell my clients now, just say no to MDLs whenever you can. And I would recommend, don't ever waive any jurisdictional defense that you have. Don't waive lexicon. Don't let them go and put these cases to trial. And furthermore, do not consent to the direct filing of cases in MDLs. After BMS, I can see no possible jurisdictional basis for allowing direct filing of cases other than the defendant's waiver of jurisdictional defenses. And if the MDL judges seek to create it anyway, this could be the next lexicon. MDL plaintiffs are desperate for any waivers that they can come up with because, again, their business model depends on them being able to ignore differences between plaintiffs, and personal jurisdiction after BMS forces them to engage in individual plaintiff by plaintiff litigation, and that's exactly what they don't want. And the waiver arguments we saw in the mandamus action in the Pinnacle Hip litigation is indicative of the desperation of the plaintiffs and the judges that seek to go and force settlements. Another thing I haven't heard discussed is the limitations that personal jurisdiction places on ancillary discovery. This was things such as discovery and aided execution or third-party subpoenas. There must be personal jurisdiction over any person as to which the court's coercive power is being asserted. That requires jurisdiction. So thus there must be personal jurisdiction over third parties from whom non-party discovery is sought. And courts have routinely ordered third-party discovery. and they particularly do it against financial institutions in aid of execution. And there are increasing numbers of cases recognizing that in those situations you have to go to someplace where you can actually obtain personal jurisdiction over the financial institution or other party against whom one is attempting to subpoena information. Another place where I think personal jurisdiction is the handwriting on the wall is in nationwide state law class actions. The key here, I think, is how BMS distinguished Schutz, which involved non-resident class members in a case, due process situation, where the defendant was asserting a lack of personal jurisdiction. And the court in BMS, in distinguishing Schutz, held that authority to entertain non-resident class members is entirely different from authority to exercise jurisdiction over out-of-state defendants. And when you are dealing with a nationwide class action under state law, as to all but one of the states, the defendants are going to be non-residents. And since it's in one jurisdiction, that also means that as to everyone but one of the states, the class representatives are going to be non-resident. And any time from now on, when you have non-resident plaintiffs suing non-resident defendants, there are going to be serious jurisdictional issues. And Rule 23, being a rule of civil procedure, cannot expand any party's substantive rights. So therefore, it cannot create personal jurisdiction. So any nationwide class action is going to require multiple subclasses on state law issues, and the non-resident plaintiffs suing non-resident defendants are going to raise jurisdictional issues. And I believe that eventually the idea of a nationwide class action is going to be limited to places where, under Bauman, the corporation is at home, which means their principal place of business or their state of incorporation. And furthermore, since each defendant's jurisdiction is separately determined, this idea of joining multiple different defendants in an entire industry in nationwide state law class actions will be impossible, because each defendant is going to have an establishment of jurisdiction, and that will not be possible with multiple defendants from multiple states. And finally, I saw this when I read the T.C. Heartland case that was mentioned earlier. Another relatively little-known effect of Bauman and BMS, it has to do with the federal venue statute. The federal venue statute limits venue to where there is personal jurisdiction over the defendant. That wasn't much of a limit when we had, with respect to large corporations, when we had general jurisdiction on the basis of simply continuous and substantial. But now that means is that federal statutes that do not have an independent jurisdictional venue grant in the statute themselves are themselves going to be limited by Bauman and BMS. And thus personal jurisdiction in federal cases is also impacted. Now BMS specifically reserved the question of Fifth Amendment federally based jurisdiction in the opinion. However, the statute we see from the T.C. Heartland case, when you read it, the statute itself puts the two together. So it is clear to me that at least under the current statute, we are going to have a situation where BMS and Bauman restrictions on personal jurisdiction are going to go and come to play in the federal cases. And that's my presentation. Thank you.
Thank you, Jim. Phil?
Thanks, Glenn. I always like hearing Jim talk, because I feel like I learned so much about all these different nuances of the issues. As Glenn said earlier, my name is Phil Goldberg, and I'm a public policy attorney. And so my practice deals with looking at issues and policy issues, liability issues from a macro level. So if there's a case or an issue, you might hire someone in the court to defend you, but you're going to work with somebody like us or Jim at the macro level to say, what should the law be? How should it be applied? And looking at other external factors like judicial temperament or how the media is handling a particular issue. And so a lot of our practices are in areas like amicus courts, working with WLF, other trade groups, individual clients file amicus briefs, judicial education programs, legal scholarship. We work at the legislative area, Congress and state legislatures, in terms of testifying and providing support for that. And then, of course, when the agencies get involved with liability issues. The other hat that I'm here wearing today is as the director of the Progressive Policy Institute Center for Civil Justice. And the Progressive Policy Institute, they've been around for 25, 30 years as a driver of pro-economic policies and pro-growth policies from the center left. And about 2 years ago, we set up the Center for Civil Justice underneath PPI's banner because we wanted to make sure that not one interest group could define what progressive legal philosophy is. And unfortunately, that's what was happening. And that too often, the voice of moderates and center-left progressives who wanted to see civil justice, who wanted to see the civil justice system work out and produce the right results and provide fairness to defendants just as to plaintiffs, our voice wasn't being heard. And so we want to make sure the courts remain a public good where the right result you get to the right result by the end of the day. And one of the keys that we've found in our public policy efforts with PPI is to make sure that we're not just talking about what the law is, and we're not just talking about why it's fair to either our clients or businesses or what have you, but it's really talk about the system and why this is the right result for the system, why they're building the best mousetrap. And I remember several years ago, this concept was informed by talking with a friend of mine who at that point was chief of staff to a ranking Democrat on a committee of important jurisdiction in Congress. And he said he was sick and tired of all these companies coming in and saying, here's what the law ought to be because it's not fair to us. He's like, I don't care what's fair to them. I want to know what consumers or patients or whoever the issue is, what's the best answer for them? And if you can explain to me why what's best for you is also what's best for them, then I may listen to you and go along with it. So that's kind of how we kind of orient ourselves and how we look at issues, much like the ones that Jim has talked about, that I'm going to talk about today on the jurisdiction issues. And so for the next 15 minutes or so, I plan to talk about jurisdiction and venue from a judicial fairness perspective, also looking at it in the context of the realities of today's economy. Where you have a lot of smaller companies doing business around the country and around the world, particularly in the internet economy. We also look at some of the practical implications of these rulings on state litigation and state civil justice efforts. And I'm going to do my best not to overlap with what Jim said, and I'm pretty confident that there may be only a few moments where we'll say the same things. So with respect to judicial fairness, let's make no mistake about it. And what's clear from these rulings is that litigation tourism distorts justice. It is a purposeful gaming of the system to get an advantage that you're not due. And this comes right out of the plaintiff lawyer mass torts playbook, where they have jurisdictions that they cultivate to give themselves an advantage. They use attorney advertising and all that to generate a mass number of claims, a lot of which are not merited. They stockpile those cases into these favored jurisdictions, and then they leverage both the venue that the defendants don't want to be in and the mass number of claims that they have stockpiled there to get mass settlements. The American Tort Reform Association calls these judicial hellholes. Dickie Scruggs called it my magic jurisdictions. Two sides of the exact same coin. So what I find important about these rulings from the Supreme Court that Jim went through is that 5 times or 6 times in the last few years, 3 times in the last term, the court spoke loudly and with a largely unified bench that forum shopping and litigation tourism is no longer to be tolerated. Because these cases were largely unanimous, you're not going to find the public policy or the anti-litigation abuse language that there might have been in a narrower ruling. Because Justice Ginsburg, who wrote one of the opinions, Justice Kagan, Justice Breyer would not join an opinion that was that overt. But read Justice Sotomayor's dissents. She tells us exactly what these cases are about. And that's what should be used and leveraged as we're defining and holding on to these victories and explaining to other courts why they should understand them and understand that forum shopping and litigation tourism into these magic jurisdictions is wrong and that the Supreme Court has explained that. So I'm going to go through these cases in a slightly different way that Jim did, not less from a doctrinal perspective, a little more from a public policy view. So looking at Goodyear, the general jurisdiction cases, starting Goodyear, then Daimler, and now BNSF, which was an 8-1 ruling. Why did the plaintiffs want to go to Montana so badly? I can say from experience, I don't think a Montana court has ever seen a summary judgment motion that it's ever liked. But with respect to this case, it's a favored jurisdiction for FILA cases. They have a longer statute of limitations. They give life to cases that would be barred in other jurisdictions. So this was a bold attempt to take a case that arose completely outside of Montana and get it into a Montana court because it was perceived as a friendly jurisdiction for them. I briefed this case along with my colleagues on behalf of the National Association of Manufacturers to the Supreme Court. And what we explained to them, and what I think is valuable here, is that the shift to at home from the minimum context, as Jim was explaining, is an important part of today's economy. Back in the minimum context, it may have been a little bit less usual than it is today to have contacts in states far away from where you're at home. Now, like I said, you have small businesses that are doing business all around the country. They should not be subject to this kind of all-purpose or general jurisdiction in any state where based on how many contacts they have. They've not availed themselves of their jurisdiction, and so where they're at home to be sued for anything and everything, that's the place where it should be. The court got that right, and we need to make sure that the lower courts understand that. On the specific jurisdiction cases in Bristol Myers Squibb, here the plaintiff went to extraordinary lengths to file in California. They took individual plaintiffs who may have had legitimate jurisdictional stake in California courts, and then they attached 80 some odd cases to that plaintiff through a joinder because they knew those cases on their own would never have jurisdictional standing. But they said, okay, we're going to put them all together and attach it to this case that does, and then we're going to pretend that we have jurisdiction. And the courts were allowing them to do this. And then St. Louis allowed them to do this, other states allowed them to do this. So why? Well, why would they want to be there so badly? California in 2015 was named ATRA's #1 judicial hellhole. The LA courts have for a long time been called the bank for giving out money to plaintiffs' lawyers. These magic jurisdictions, in Dickie Scruggs' words, are grabbing onto cases and taking cases from other states that they really have no right to. And the states' rights issue was important in the Supreme Court when they heard the Bristol Myers Squibb case, and Justice Gorsuch really talked about that a lot. Because he really saw this as states' rights, one state taking a case that was the property of another state. Again, there was a broad 8-1 ruling. The patent case that Glenn mentioned and Jim referred to, T.C. Heartland, this was a venue form shopping case dealing with patent litigation, which has long been a problem. They've had favored jurisdictions in Texas, in Marshall, Texas, with the federal district court there. It's been known as a rocket docket for patent cases, purveyor of where patent trolls tend to rise up and sue people and leverage the litigation and leverage the jurisdiction for settlements. And the Northern District of Virginia has been known as a rocket docket for patent litigation. And this has been a long theme for a major theme for a significant number of years. What's interesting about T.C. Heartland is that it had nothing to do with these jurisdictions. And it had nothing to do with patent trolls. But that is where this ruling is being felt the most, because that's really where this ruling was aimed at. It was an interpretation of the venue statute for patents. It was not a constitutional ruling like the others. And the court was unanimous here in saying that the venue is where the defendant is incorporated or where the act of infringement occurred and the defendant has a, quote, regular established place of business. So what happened after T.C. Heartland? There have been 350 motions to transfer out of the Eastern District of Texas. You've had the new filings in the Eastern Texas and Marshall, Texas have gone down, and they're up in places like Delaware where people are incorporated. So it is having a significant impact. Now, the court in Marshall doesn't want to give up these cases. This is what they do. They've cultivated this, and they're part of this. The aggregation of cases. They want those cases. It's their business, and so they tried to hold on to them in ways that other courts we've seen in what again Scruggs calls them as magic jurisdictions have tried to do. And so they've said that in several cases that if the cases have been ongoing, that jurisdiction was waived or venue was waived in these cases because it was never raised early on because, you know, let's face it, the Supreme Court just ruled on it. You didn't have that case to lean on a year or so ago. Judge Gilstrap, who's issued what he called a 4-part test to define when a defendant has a regular established place of business. In this 4-part test was designed so that he can try to hold on to the cases. One was if there was a physical facility there, he would say, yeah, that's good enough. Then he wants to see if the defendant told people at operations there, so based on some of their marketing materials, whether the defendant derives benefits from the local jurisdiction, and then other specific contacts. And then he wanted to allow discovery into marketing efforts and all of that to decide if there was, so the plaintiff can try to make the case for why there should be there should be venue in that jurisdiction. The U.S. Court of Appeals for the Federal Circuit looked at patent cases, struck down this 4-part test just recently in In re Cray. And what was I thought important about that case, in addition to, again, the doctrinal aspects of it, was it did talk about the interconnected economy and how you have, you know, today's economy is not, you know, you need to restrict venue and jurisdiction rules. So what happens next? You know, all the bad cases go away. There's no more litigation abuse, so that's not going to happen. Litigation, in my view, is like water and money and politics. It always finds a way through. And so let's look a little bit about what we think the litigation landscape is going to look like. So first, where are these cases going to go? There's going to be an increased importance at the at-home states. So look at where the companies are based. Now, the major employer states, New York, California, Illinois, where you have major metropolitan areas, you have a lot of companies that are based. That's hardly comforting for a lot of people because that's where a lot of these magic jurisdictions / judicial hellholes are. And so that, you know, there's going to become a greater civil justice battleground in these states over what the laws are going to be, whether it's legislative tort reform or pro-plaintiff reforms, whether it's going to be through the courts. There is a very important Missouri judicial selection vote happening over the next couple of weeks to decide who's going to be on the judicial selection panel that nominates appellate judges to the governor. And this is where you're seeing some of these dynamics play out, where you have the plaintiff lawyers trying to get their people onto those judicial selections. And so, you know, if anyone is in Missouri, I encourage them to take a look at that. And particularly the eastern half or eastern third of Missouri is where the election is right now. So what will the mass tort defendants do? You know, a lot of companies already are looking at the judicial climate in a state to decide where they're going to locate their headquarters, where their principal place of business is going to be. That's going to become even more important now. And so, are they going to move to places where when they're at home, they're really, you know, they think the laws are a little more fair, maybe more business friendly. We might see more of a migration to those states. And what will the plaintiffs' lawyers do? Well, obviously, they're going to keep focusing on some of their magic jurisdictions in some of the bigger at-home states. The second thing, and this dovetails a little bit what Jim was saying, is that, you know, the paint is not dry necessarily on what these cases mean. We all think we know what this means, but we've got to figure out how it's going to be applied and how they're going to be interpreted in individual cases. And so the plaintiffs' lawyers are already working very hard to narrow the doctrines in these cases. And I assure you, never underestimate the persistence and the creativity of the trial bar in getting its way, at least in the places where they cultivate. So, you know, the exceptional cases exception, I agree with Jim. It should never be. There hasn't been one yet. It's supposed to be based on the exceptional amount of contacts the defendant has. If history is a guide, the plaintiff lawyers are going to try to make it an exception based on the unfairness of the plaintiff. I anticipate that that's going to happen. Can the state extract a personal jurisdiction waiver for doing business there? Jim talked about that a little bit. Does that change the due process analysis of notice? If there's a notice by statute that you're going to be subject to general liability in the state, does doing business there then defeat the due process analysis. I don't think so. Jim doesn't think so. It shouldn't, but that's where the plaintiffs, that's what they're going to argue, and that's where they're going to go. With respect to specific jurisdiction, there's a lot of words and terms that did not get defined in the BMS case. What does substantial connection mean? As Jim was had up his slide about what substantial connection. What does arise out of or relate to mean with respect to the defendant's contacts in the state? The chain of commerce stuff that Jim was saying. What is acted in concert with? We all think we know what that means. But now things may change, or at least the plaintiff lawyer arguments are going to get more creative because they're going to be more desperate to hold on to some of these cases. And so joint conduct and in concert will be litigated. And so the defense community needs to be vigilant if they're going to stop these expansions. A few other thoughts to share before we wrap up and take questions. One is that the asbestos cases, and Jim made reference to this. In fact, I was at a discussion this morning where a general counsel of a major company that has asbestos case said all of his cases in Madison County, New York City, he's getting out of all of them because of this. And they're not refiling against him because he's such a small player that it was great when they could do phone book style pleading and name dozens of companies, but they're not going to go file a separate suit against him in his state. And then you're going to end up having, if they don't want to sue where the plaintiff was injured, where there might be specific jurisdiction, they want to go where a defendant is because it's one of these favored jurisdictions. Then they may have different suits around the country, all based on the same exposure, going after where each of the defendants is at home. How are the courts going to work through that? How are people going to have cross claims? Are they going to offsets for a judgment in a different jurisdiction? How is all that going to work out? I think we don't know yet, but that's certainly an area to be mindful of. Also, if more claims are filed in at-home states, what's the impact is that going to be on the ability to remove a case to federal court if it's harder to defeat diversity? Class actions, Jim talked about this a little bit, and Justice Sotomayor flagged this in her dissent. The majority opinion was clear that the mere fact that other plaintiffs can invoke case-specific jurisdiction in California does not allow the state to assert specific jurisdiction over non-resident claims. These were mass aggregated claims, just like a class action is a mass aggregated claims, different function, joinder versus class action, Rule 23. Shouldn't the same law be applied? The answer should be yes. The plaintiff attorneys are already arguing that the non-named class members are in some courts not considered parties for some issues but not for others, and so they should not be considered parties for the purpose of jurisdictional analysis. That's where they're going to go. The other area that I think we really need to focus on are the state venue laws. In the states where you're at home, if you're located in upstate New York or central Illinois or somewhere in Orange County, California, you don't want to be sued in New York City or Chicago or Madison County or LA. If you're in Missouri, you don't want to be sued in St. Louis. It's important, the state venue laws decide where in that state you can sue. So even if you have jurisdiction, even if that's legitimate, you want to make sure you're not dragged into one of these jurisdictions based solely on the fact that that's where the plaintiff files the case. You want to make sure you can get into the proper jurisdiction, which is the county or that maybe you're at home in. And so the place where that is really coming to fore is in Missouri. Missouri venue reform is one of the highest priorities that the Civil Justice Committee is focusing on right now, and it should be. And the Missouri Supreme Court came up with a ruling about 2 or 3 weeks ago that even put a finer point on why reform is needed by the legislature. About a year ago, the Missouri Supreme Court came out with a jurisdictional ruling in Norfolk Southern versus Dolan, but it didn't stop the joinder of these mass number of cases to local lines, just like in California it was happening. In St. Louis, they were taking dozens of out-of-state plaintiffs and attaching them or joining them to in-state plaintiff claim to try to defeat jurisdiction. And the courts were complicit in this and allowing it to happen. they had a good jurisdiction ruling in Norfolk Southern versus Dolan, and the lower court said, oh, that doesn't affect these joinder cases because that would only affect the primary plaintiff. It doesn't affect all the cases that are joined on. So they kind of got around that. What will the impact of Bristol-Myers be? Different courts came out with different rulings. And again, they're trying to hold on to these cases. This is what they do. This is their business. And so we're initially seeing that defendants waived their challenge to personal jurisdiction, sometimes because they didn't raise it, sometimes because they raised it, but they had to continue litigating the case, going through discovery, and the court said, well, once you go into discovery, then it's too late to raise jurisdiction challenge. And so the impact of that may be that some defendants are now going to not engage in any discovery. They're going to put off these cases until jurisdiction gets decided, which isn't necessarily what's best for the plaintiffs either. It's probably better for the plaintiffs, frankly, for this to work on a concurrent track. But the case that came down a couple months ago, or maybe a month ago, was trying to be plaintiff friendly, but ultimately I think it may end up hurting them. The new cases shouldn't be affected by the waiver issue. A couple weeks ago, the Missouri Supreme Court ruled in Abbott Labs that basically gave a free ride to those who want to game the system by filing in the wrong venue in Missouri. What it said is that venue is just like any other procedural rule, and they're only going to look at it if the defendant can show they were prejudiced by the fact that it was heard in the wrong venue. So the plaintiff chooses where to sue. They go to St. Louis City, they file their claim in St. Louis City. Defendant makes a motion, no, St. Louis City is not the right venue for this. It's St. Louis County, it's Kansas City, it's Jefferson City, wherever it might be in other parts of the state. And the local court says, no, we don't agree with that. You have to litigate the whole case. Then you finally get to an appellate court, and the appellate courts are now saying, show me how you were prejudiced. That would be like asking the Nationals to play all 5 games of this National League Division Series at Wrigley Field, and then having to prove which balls and strikes would have been different if you had umpires calling the game at Nats Park. It's not going to happen. You can't do it. So as a result, none of these the plaintiff's going to file in the wrong venue on purpose, and they'll never get overturned. They'll never get changed. And so having clear venue rules in Missouri that require courts to deal with these issues and apply the law properly is critical. So in conclusion, the importance of these rulings that Jim went through and I went through, it cannot be understated. This is a broad rejection of forum shopping by the U.S. Supreme Court. But the paint's not dry. The plaintiff lawyers are working very hard to chip away at them. And the local courts are trying to hold on to these cases as best they can. And so we need to be vigilant and need to keep working at it to defend what the victories in the Supreme Court and make sure they're applied correctly. It also should, what I call the trial lawyer smoke machine. They create a lot of smoke. They get all these cases filed, but there's really no there. It's under the belief that if there's smoke, there's fire, but there's really no fire. This should help stop and curb the ability of them to just pile up on these cases and leverage the system. And so with that, I'll turn it back to Glenn and happy to answer questions. Thank you.
Thank you, Phil and Jim. Going to invoke the moderator's privilege and ask the first question. Plaintiffs' lawyers are obviously going to be active in trying to craft how the law goes about in this area. Do you think that these rulings in any way are going to put a crimp in their desire to expand liability theories, come up with new ways to sue? Is that going to be more difficult now that they're not going to be able to file lawsuits wherever they want to file them?
Is this on?
Yeah.
This is Jim. It will, to the extent that you are coming up with things like industry-wide liability theories, because unless they're willing to go and bring those suits where the defendants are at home, they're not going to be able to herd these theories, to go and herd these theories. I mean, even when you do have an issue where a defendant is at home, if you have multiple defendants, you're not going to be able to raise things like market share liability, which is to to take a 1980s example of an extreme expansion, because the companies are located in different places, so the plaintiffs are then going to have to sue individually where they are located, and unless they happen to be in one of the magic jurisdictions already, those kinds of theories are not going to help them very much. I mean, there's 54 million people or something in California, so maybe they'll continue with it, but it's not going to help in a lot of the smaller states.
I think that's largely right, especially on where the theories are based on multiple defendants. I do think, again, I never understood the creativity of people who are trying to expand liability to figure out, how can I sue for people who aren't injured? How can I sue for more than they're rightfully owed? And how can I sue companies that didn't do anything wrong? That's where the plaintiff lawyers have been going over the past 15 to 20 years. I expect they're going to keep trying to do that. Sometimes if they find the right court, they can win there. Then they go to the next court, and they can win there. So they may not get this sort of the one-stop shopping where they can get to get that kind of change nationally. But all they have to do is win in a few jurisdictions, and then they start chipping away at it, and then they can try to bring more cases there. But the impact of those rulings, as Jim was saying, will be less on companies that aren't based in those states.
With something such as asbestos cases, if these get split up and plaintiffs have to sue in multiple cases, places where plaintiffs tend to pile up, where they like to sue, tend to be slower. And if you have issues with the law of the case or collateral estoppel, if the defendant wins one of these asbestos cases in, say, North Dakota, and then they try to bring it to New York, you're going to have serious issues of having to deal with collateral estoppel in some of those situations.
Again, please, if you're online and you're interested in asking a question, please do so in the Q&A template that's there next to the video screen. Phil, I was curious, I was very interested in your sort of take on why it's important to explain why liability limitation and civil justice reform is important to consumers. What would your sort of pitch be as to why being in the right jurisdiction is positive for consumers in the end and for plaintiffs, not necessarily just for defendants?
Well, I think, at the end of the day, you want the right result. You want the court system to end up in the right result because there's unintended consequences. So you may win as a plaintiff in this particular jurisdiction, but that's going to change economic activity. That's going to make it harder for maybe U.S. companies to compete against foreign companies that don't have to live under the same rules. That's going to make a product get changed. So if you find a design defect in a product, there really isn't a design defect in it because somebody, because there's a Daubert ruling or something that happened in a specific court, that they're going to have the company now has to change that product in that case to address a problem that really didn't exist, and they are going to take away benefits that maybe other consumers would have preferred to have of that product. So an example would be we saw a case in Kentucky about 2 years ago where it was a rollover of a convertible, convertible rolled over, and the defendant, the car company, was held responsible for punitive damages for not having a rollover that would protect the person from having a car that would protect the person from a rollover. And they had, of course, there was some plaintiff's expert that went up there and explained some wild theory about how the latches on the car should have kept everything intact. If you look at the highway safety rules, the car rules, they're exempted from roof crush standards because there's no roof. Even if the ragtop is closed, it's really not effective. And so, if you have a judge in those jurisdictions that allow that kind of stuff through, then you're going to end up taking away options like convertibles that people like. Unfortunately, the issue got straightened out on appeal. But those are the kind of trade-offs that you see where benefit to one may cause an injury to another that you see in designs of complex products like automobiles all the time. And we need courts to look at it more broadly and say, and if we can present what's best for consumers on the broad scale, even though that may not be the right, the answer that you would like to see for that specific plaintiff in that courtroom, that's how we can try to help explain some of these legal issues and more broadly in some of the ways I was talking about.
Well, I think another explanation personal jurisdiction now being much more dependent on real contacts between a defendant and the jurisdiction, the defendant can change these contacts. It has some costs and all, but it comes down to jobs. And if you have a very poor litigation environment, now that you can't simply be hauled into court for continuous substantial contacts, you have to be at home, they can change their home. And that's going to go and reduce the number of jobs available. And another thing, sort of personal to me, is I live in Philadelphia, is we also get called for jury duty on these things. And we are here to litigate and think, why are we listening to someone from Utah?
Jim, I know you know how to get out of jury duty.
I can get out of jury duty. This is for other people that aren't lawyers and don't know what to say necessarily. But people are called for jury duty for cases that have nothing to do with anything that their jurisdiction should be dealing with. And so you're putting that kind of imposition on the people, and you have also the imposition on the court system that means that these out-of-state claims are crowding out the time that should be spent on disputes that are among residents of the jurisdiction.
Question from an online viewer. Yeah, Jim had been talking about in the MDL practice context not consenting to direct filings of complaints in MDLs. One of the questions is, in MDLs, can you negotiate an order taking care of problems with direct filings? Are there risks with doing that sort of thing in the light of what's happened with Baumann?
Of course, because personal jurisdiction can be waived, and so any defendant who wants to, for whatever reason, make it easier for the plaintiffs to file cases, could consent to direct filings. I see no reason, since I see no jurisdictional basis for allowing direct filings, I see no reason why, unless the defendant can get some other kind of concession somewhere else, that there's a good reason to do that, and that thus make it easier for the plaintiffs to file cases.
One thing that hasn't been discussed a lot in this area is sort of business versus business litigation. One of the cases that come out recently involving personal jurisdiction was the Illinois Supreme Court came down with a ruling on the fact that consenting jurisdiction does not come out of your registering to do business there. That was two businesses that were involved in that litigation. Are there areas that you see these decisions impacting or businesses or suing businesses other than patent litigation, which is kind of the obvious one?
Generic drug manufacturers and branded drug manufacturers sue each other all the time. And before BMS in particular, the ability to sue generic companies in one court has been, in an efficient fashion, has been something that branded drug manufacturers like to have. And thus, I have seen branded drug manufacturers on the business side asserting broad jurisdictional theories because it helps them in the cases. And we came very close to an issue there in I guess it's technically patent litigation in the Federal Circuit, where there was an attempt to have a broad consent to jurisdiction theory. And they resolved that by deciding it on other patent-specific grounds, and was ultimately taken care of by the Delaware Supreme Court's rejection of consent jurisdiction. But yes, businesses who, when they are plaintiffs, like to be able to engage in the same kind of forum shopping every other plaintiff does.
Another question from an online viewer. Both BMS and BNSF leave unresolved the permissible scope of federal courts applying federal jurisdictional statutes. Jim talked about that a little bit. There are a small number of federal statutes that provide for service upon a defendant, although not according to the long-arm statute of the state where the district court sits. These statutes permit service on a defendant anywhere within the territorial limits of the United States, such as the Securities and Exchange Act, the Clayton Act, and RICO. What, if any, constitutional limits should apply in those situations?
Congress has the authority to go and extend venue, at least, to the extent to which it has authority to create jurisdiction would be limited by due process. So I believe that one should look and see, look for examples where the application of a nationwide service of process statute has created nationwide jurisdiction would, under the Supreme Court's theories, result in something that is not fair, or you don't expect that you'll be hailed in the court in a jurisdiction where you do not have any purposeful contacts. And that would be the kind of case in which to challenge that. I do not know where those challenges would come out. Those cases haven't been brought yet. But that if you're attempting to extend the jurisdictional analysis to a situation where Congress has, in fact, attempted to expand jurisdiction, that would be where I would start. I'd try to get a good case of the facts.
I agree with that. I think, you know, if you look at the cases we're talking about, it's you know, the constitutional issues here involve federal, the U.S. Supreme Court saying that states cannot take these cases that are due to other states. If you're dealing with federal venue, you know, the federal judiciary is one judiciary. And so if Congress has established which venue among the federal judiciary that those cases can be brought, or if they can be brought, you know, the venue statutes, it would have to be more of probably a forum non-convenience or some sort of fairness-based approach to explain why, you know, if all the activity of a case happened in one district or one area of the country, it shouldn't be brought in court in a different one. And I think, you know, the T.C. Hartland case and the patent, you know, that looked at the venue statute that governs patents. And so if you can take the T.C. Hartland concepts and apply it to maybe some of these other statutes, and again, I don't know what these other statutes exactly say, but if they're comparable to T.C. Hartland, that should get you where you need to go, not as a basis of constitutional challenge or jurisdiction, but as an interpretation of the federal venue statute.
Jim, any thoughts on why the Supreme Court didn't grant review in the MM versus GSK case, and does it really have a huge impact going forward?
I think there is some reticence in the court generally to take a case immediately after it has decided an issue, but is more interested in having it percolate and seeing the arguments that are developed in response to its own decisions. That being said, I saw no reason why they couldn't have GDR'd it and just ran vacate and reverse, or in remand rather. But they didn't, and I don't think that is predictive of anything, given the fact that it was that the BMS decision was the 8-to-1 ruling.
It also came from directly from an appeals court in the state as well, which is
court
right.
The Supreme Court did not decide it, so maybe that would be another factor why I didn't think it was that big of a case to put on its these days very limited docket.
Well, I think that about wraps up our time. I want to thank you both for joining us today, and anyone who is online and by chance joined us late or has colleagues that might want to watch this, it will be available as an archive file on our homepage. And we'll also be sharing a lot of the materials that we have developed in the area with those of you who registered. And if there's anyone that is watching online that has interesting cases in this area where a WLF amicus brief or a plaque amicus brief or a ATRA amicus brief might be beneficial, you know, be in touch with our speakers, be in touch with us, and we'll continue to push these areas forward. Thank you, gentlemen.